Senator Chuck Grassley. Let's listen in.
On the nomination of
Mr.
Judge
Chairman.
Brett Kavanaugh
Mr. Chairman.
to serve as Associate Justice.
Mr. Chairman,
on the
I'd like to be
Supreme Court
recognized
of the
for a
United
question
States.
before we proceed.
Regular order, Chairman.
Mr. Chairman, I'd like to be recognized to ask a question before we proceed. The committee received just last night, less than 15 hours ago,
Mr. Chairman, regular order.
42,000 pages of documents that we have not had an opportunity to review or read or analyze.
You're out of order. I'll proceed.
We cannot possibly move forward, Mr. Chairman,
I
with this
extend a
hearing.
very warm
We have
welcome
not
to
been
Judge
given an
Kavanaugh,
opportunity to have a meaningful
his wife,
hearing on
Ashley.
this nominee.
their two daughters.
Mr. Chairman,
Their
I
extended
agree with my
family and
colleague,
friends.
Senator Harris. Mr. Chairman,
Judge
we
Kavanaugh's
received
many law
42,000
clerks
documents that we haven't
and
been able
everyone else
to
joining us
review last
today.
night, and we believe this hearing
I
should be
know this is an
postponed.
exciting day for all of you here, and you're rightly proud
Mr. Chairman,
of
if
Judge.
we cannot be recognized, I move to adjourn.
The American people.
Chairman, I move
get
to adjourn.
hear directly from Judge Kavanaugh later this afternoon.
Mr. Chairman, I move to adjourn. Mr. Chairman, we have been denied real access to the documents we need to advise.
Chairman,
and
regular
defend,
order is called for.
which turns this hearing into a charade and a mockery of our norms.
Well-
and Mr. Chairman, I therefore move to adjourn this hearing.
Okay.
This is a mockery and a travesty of justice. This is a travesty of justice. We will not go back. Cancel Brett Kavanaugh. Adjourn the hearing.
Chuck? Command order. Chuck. There's a motion to adjourn.
We're not in executive session.
Mr. Chairman, I ask for a roll call vote on my motion to adjourn.
Okay.
Mr. Chairman, I move to adjourn. I ask for a roll call vote.
We're not in executive session. We will continue as planned.
Mr. Chairman, may I be recognized, sir? Mr. Chairman, I appeal to the chair to recognize myself or one of my colleagues.
You're out of order.
Mr. Chairman, I appeal to be recognized on your sense of decency and integrity. Even the documents you have requested, Mr. Chairman, even the ones that you said, the limited documents you have requested, this committee has not received. And the documents we have, you, sir, have
Chairman,
labeled
I'd ask
committee
for regular
confidential.
order.
They should be transparent. This committee, sir, is a violation of even the values I've heard you talk about time and time again. The ideals that we should have. What is the rush? What are we trying to hide by not having the documents out front? What is with the rush? What are we hiding by not letting those documents come out? Sir, this committee is a violation of the values that we as a committee have striven for, transparency. We are rushing through this process in a way that is unnecessary. And I appeal for the motion to at least be voted on.
Mr. Chairman.
At least let's have a vote, because when we wrote you a letter on August 24th
Senator.
asking to have a meeting on this issue, you denied us even the right to meet. So here we are having a meeting. Let's at least debate this issue. Let's at least call this for a vote. I
Senator.
appeal to your sense of fairness and decency, your commitments that you've made to transparency. This violates what you have even said and called for, sir. You've called for documents, you yourself, limited documents. We thought there should be more. We have not received the documents that you have even called for. So, sir, based upon your own principles, your own values, I call for at least to have a debate or a vote on these issues and not for us to rush through this process.
Mr. Chairman.
Senator.
Mr. Chairman, I've
Senator,
heard calls for
I'd like to
regular
respond.
order.
I'd like to respond to Senator Booker. Senator Booker, I think that I respect very much a lot of things you do, but you spoke about my decency and you spoke about my decency and integrity, and I think you are taking advantage of my decency and integrity. So. Okay.
The order, it is regular order for us to receive all the documents, that this committee is entitled to.
Okay.
Mr. Chairman, it is also,
I think that
Mr. Chairman,
I-
it is also not regular
Hey,
order for the majority
Senator
to
Rono.
require the minority to pre-clear
Sen-
our questions, our documents, and the videos we would like to use at this hearing. That is unprecedented. That is not regular order. Since when do we have to submit the questions and the process that we wish to follow to question this nominee? So I'd
Senator,
like your clarification. I'd like your
Senator
response
Rono,
on why you are
I
requesting
would
the
ask
minority
that
to
you,
submit our questions to
I ask
you.
that you stop so we can conduct this hearing the way we have planned it. Maybe it isn't going exactly the way that the minority would like to have it go, but we have said for a long period of time that we were going to proceed on this very day, and I think we ought to give the American people the opportunity to hear whether Judge Kavanaugh should be on the Supreme Court or not. And you have heard my side of the aisle call for regular order, and I think we ought to proceed in regular order. There will be plenty of opportunities to respond to the questions that the minority is legitimately raising, and we will proceed accordingly.
Mr. Chairman, under regular order, may I ask a point of order, which is that we are now presented with a situation in which somebody has decided that there are 100,000 documents protected by executive privilege, yet there has not been an assertion of executive privilege before the committee. How are we to determine whether executive privilege has been properly asserted if this hearing goes by without the committee ever considering that question? Why is it not in regular order for us to determine before the hearing at which the documents would be necessary whether or not the assertion of privilege that prevents us from getting those documents is legitimate or indeed is even an actual assertion of executive privilege? I do not understand why that is not a legitimate point of order at this point, because at the end of this hearing it is too late to consider it.
Mr. Chairman, if I might add to this, on the integrity of the documents we've received, there really is no integrity. They have alterations, they have oddities, attachments are missing, emails are cut off halfway through a chain, recipients' names are missing. Many are of interest to this committee, but it's cut off. The National Archives hasn't had a chance to get us all that we want, even though you said on your website the National Archives would act as a check against any political interference. But I check after the hearing is over is no check. I think we ought to at least have the National Archive finish it, and to have, for the first time, certainly in my 44 years here, to have somebody say there's a claim of executive privilege when the president hasn't made such a claim just puts everything under doubt. What are we trying to hide? Why are we rushing?
I can answer all the questions that have been raised, but I think if I answer those questions, it's going to fit into the effort of the minority to continue to obstruct. And I don't think that that's fair to our judge. It's not fair to our constitutional process. But let me respond to those now, and then maybe we can proceed. My colleagues on the other side are accusing the administration of using executive privilege to hide documents from the committee. I want to say why they're wrong. Unlike President Obama's assertion of executive privilege during Fast and Furious is one example. This assertion is not legitimate. Judge Kavanaugh was a senior lawyer in the White House. He advised the president on judicial nominations, provided legal advice on separation of powers issues, and handled litigation matters. As the Supreme Court has put it, quote, unless the president can give his advisors some assurance of confidentiality, a president could not expect to receive the full and frank submissions of facts and opinions upon which the effective discharge of his duties depends, end of quote. The issues Judge Kavanaugh worked on are exactly the sort of issues that require, according to the Supreme Court, some assurance of confidentiality. We in the Senate and everyone else in America expect exactly the same sort of confidentiality. Most senators would not agree to turn over their staff's communication to anyone. For example, we didn't ask that Judge Kagan's records for her service with then Senator Biden be turned over during her nomination. And because of attorney-client privilege, everybody has a right to keep communications from their lawyers out of government hands. We therefore didn't ask for Justice Ginsburg's documents from her time with the ACLU. We didn't ask for Judge Sotomayor's confidential documents from her time in private practice. It can't be that the Senate and the ACLU are entitled to more protection than the President of the United States. And then I will speak to the fact about 42,000 pages. Last night, we received additional documents for the committee's review. These were documents we requested before the hearing, and we received them before the hearing just as we requested. The majority staff began reviewing the documents as soon as they arrived and has already completed its review. There is thus absolutely no reason, that's no reason to delay the hearing. We have received and read every page of Judge Kavanaugh's extensive public record. This includes 12 years of his judicial service on the most important federal circuit court in the country, where he authored 307 opinions and joined hundreds more, amounting to more than 10,000 pages of judicial writing. We also received and read more than 17,000 pages of his speeches, articles, teaching materials, other documents that Judge Kavanaugh submitted with his questionnaire, the most robust questionnaire this committee has ever issued. And of course, we received and read more than 483,000 pages of documents from Judge Kavanaugh's extensive executive branch service. This is more pages than the last 5 Supreme Court nominees combined. In short, this committee has more materials for Judge Kavanaugh's nomination than we have had on any Supreme Court nominee in history. Senators have had more than enough time and materials to adequately assess Judge Kavanaugh's qualifications, and so that's why I proceed. I know that this is an exciting day for all of you in the family and all the people that are close to Judge Kavanaugh. And you're rightly proud of the judge. The American people get to hear directly from Judge Kavanaugh later this afternoon. After this confirmation hearing and process is finished, I expect Judge Kavanaugh will become the next Associate Justice of the Supreme Court. Welcome again, Judge.